on today's event with today's wonderful speaker. So we are really fortunate to actually have Cheryl with us for about a month or so. Right now, she's a visiting scholar here at Osgood, and she's being hosted by IP Osgood. So Cheryl, Dr. Cheryl Foong, is a senior lecturer and an academic discipline lead for law at Curtin Law School, where she teaches intellectual property law and competition law. She publishes on copyright in the digital environment and speaks regularly at national and international conferences. She has a PhD from Australian Catholic University, an LLM from Columbia Law School in New York, and an LLB with first class honours, and an LLM from Queensland University of Technology. She has previously worked with the ARC Centre of Excellence for Creative Industries and Innovation in Brisbane, and has worked on direct outreach efforts to stakeholders of open content licensing, open access policy, and has authored articles, practical guides on Creative Commons licensing, and so on. So she is a very accomplished scholar already, and I know her best for her work on the Making Available Right. Her book, Making Available Right, Realizing the Potential of Copyright's Dissemination Function in the Digital Age, is an excellent book that really engages carefully with Canadian copyright jurisprudence, and that's why it's so exciting to be hosting her here. Other things, highlights, she won the Dean's Early Career Research Prize in 2019, well done, and in 2021, she was a Fellow of the Higher Education Academy. So I think with that, I will stop taking up the time and pass things over to our speaker, who's going to speak to us for about 45 minutes, and then we're going to open up. We'll have at least half an hour for Q&A after that. So if you have any questions, keep them in mind, and we'll have a conversation once we hear from Cheryl. Thank you very much again, and feel free, by the way, to get up and get seconds, whatever you like, while we do this. So enjoy the food while you're here. Thank you.
Yeah, so thank you, Karis, for that lovely introduction, and thanks for having me. It's been a real privilege to be here at Osgood Hall, and also, thank you, IP Osgood, for hosting me. Thanks as well, Emma and Erica, for setting up such a great spread for everyone today. So I thank you, everyone, for being here in person and also online. As Karis has said, I teach and research in intellectual property, but copyright really is my passion. So much of my research has focused on the area of copyright, and I'm really interested in how it evolves or has to evolve in response to technology. And I found that, in the context of the communication right and this right to make available to the public, this is where the intersection of law and technology really comes to the fore. And I liked it so much that I did a PhD on this right to make available to the public, and it was eventually published as a book. It's not really moving, I think. It's not on the slide. That's all right, I'll keep talking. So luckily, in a real highlight so far of my career was having my book, the Making Available Right book, cited by the Supreme Court of Canada. And because of that citation and because of that case, I really looked more closely at what's happening in Canada. Previously, a lot of my work was considering comparative, analysis of United States law, European Union law, and also Australian law. But what's happening here in Canada is now really interesting, and it has been, I suppose, since 2012 with the pentology. But I'm really focusing on the decision from 2022. And I'll really be highlighting three things, or the 3 points really coming out of this presentation. The first one really is how other countries, such as Australia, can learn from the Canadian approach that was, set up in this SOCAN and ESA case. Second point is looking at, at the international level, at the treaty level, other countries thinking about how they can implement this Making Available Right. What does the Canadian Supreme Court case tell them? Like, what are the flexibilities available? And I propose that it illustrates that there is a fair amount of flexibility. The third point, which I find is the most interesting one, and which I'm still in a way grappling with, is what does this case say about copyright's future? Does it kind of give us some indications, or does it chart or hint at some path forward in the future for copyright? Yeah, so the first thing really is, before I get too ahead of myself, is, where is this making available right come from? And if you're a student, if you've already studied IP, you know what copyright is. It's a grant of exclusive rights to an author, a creator, they then become the copyright owner. And these various rights can then be transferred on to different parties. So ownership of rights can be held by different parties, not necessarily by the first author. And those rights include this right to, I suppose, depends on how it's implemented, but it's right to make content available to the public. Now, this is at the international level, right? It was a response to, or the reason why they developed this right was in response to the internet and the fact that the way people were able to communicate content online was really changing. So you can think about the contrast between push type of communications versus pull type of communication. So if you think about the older kind of push form of communications, you're looking at things like broadcast, television, radio. You can switch on your TV, sure, you can switch on your radio, but what's being broadcast to you is really dictated centrally by whoever it is that's in charge of it, right? Now with the internet, if you describe it as a pull form of communication, it's really saying it's on demand. As a consumer, as a member of the public, you decide, what you want to receive. You pick and choose. And so the existing sort of international treaties, if you look at the Berne Convention, it didn't really deal very clearly with these kind of pull forms of communications. So there was this slight uncertainty or lack of clarity. So in order to address this, you have countries come together and agree on this making available right as set out in the Wide Open Internet Treaties. Now, what is set out here, this communication being made available, allowing people to access them at a place and time of their choosing. This was really a compromise. So the United States, for example, is really pushing for the adoption of a distribution right. So the form was different. Different countries preferred a different form of, right of making available, depending on how it suited their national, I suppose, context. The European Union preferred this sort of communication right, preferred making available as part of the communication right. So what we ended up with was this sort of compromise. They called it an umbrella solution, where it doesn't really matter what form of implementation it would take, so long as in substance, this right is adequately protected, this right of copyright owners. So really they were described as a sort of this compromise solution has been described as something that crosses the traditional borders. So it doesn't really concern itself about whether it has to do with transmission of copies or whether it's merely access or performances. And so another point to highlight is that at that time, they weren't really concerned about overlaps between conventional rights. The concern you can see there, if you look at the discussions or the historical records, although there could be some concerns around limitations, a lot of the discussion when it came to making available right was how do we eliminate these gaps in protection? So when the concern is mainly about eliminating gaps and there is no concern about overlaps, what you have today is what it falls upon, courts when in context of national implementation of this making available right. So I just want to remind you as well how far we've come in terms of how content is disseminated or distributed to the public. If you think about the origins of copyright, it's really about, it started with printing and publishing, right? Historically, if you look at the initial sort of industries, in terms of printing, if you look at a context of music, you can see it sort of translates into selling of sheet music, also a kind of writing. But of course, you have different ways of exploiting content. You have potentially, public performances. But historically, public performances are kind of seen as a secondary kind of right or interest in the sense that, they were useful for promoting, I suppose, interest in these primary markets for sheet music, say, historically. But then you see that incrementally, of course, there are new ways of disseminating, new ways of capturing content. For instance, you have phonographs where you can record music and play it back. So how is that to be dealt with? And ultimately, they still have to, when you have new sets of ways of exploring content arising, it still has to fit within set categories, right? You have to understand how is it protected under an exclusive right. Ultimately, of course, phonographs, recorded music, we consider these as reproductions, right? If you're selling a copy of it. But initially there was some confusion. There was a question of, well, in terms of this recorded music, for example, with piano rolls, piano rolls when there's like perforations in these musical rolls that can be replayed using the player piano. You have the U.S. Whitesmith case, concerns about, well, it's not really made to be read by people. Is that still a reproduction? But in addition, you could also say, and this is not something that has been, applied in these cases, but you could also argue that is really similar to performances as well. It's a recorded performance. It's purchased by members of the public, and ultimately they go home and they play it, even though it's in private, it's also a capture of the type of performance. So there's arguably some level of overlap even then historically. Well, we know how that has ended up, ultimately it is protected as under the reproduction right. But what I'm saying here is that when you have new means of exploitation, they could kind of fall within the gaps, and there could be, there's a period of transition where you have to figure out which right applies. But of course, when you have these means of exploitation being established, and they fall within clear categories of rights, you then have collecting societies or collective administration of rights developed around these distinct means of exploitation. And these collecting societies, they administer these collective licenses. They have, I suppose you could say, stronger bargaining power when dealing with users. And they also have an interest in pushing or advocating for broader rights. So SOCAN is an example of such a collecting society administering, performing rights in Canada. All right, so fast forward, I suppose today, streaming really is, I suppose, the most common way in which content is distributed or mass distributed. You could argue, or consumed. And the SOCAN and ESA case was really a tariff setting decision. It was a decision around what fees can be collected for what sort of uses and under what conditions. And this is just an example. This is not specifically the issue that was arising in, say, SOCAN and ESA. But if you think about things like Spotify, there's this capacity to download for offline listening. And in some ways, when you listen through a stream, that's very clearly making available, right, as a communication to the public when you stream it. When they initially make it accessible, that's making available to the public. It's not really that challenging. But you could also say the fact that you're able to download it into your device, that's a reproduction. So does this mean that these multiple rights will require remuneration or require authorization? Because it crosses, I suppose, this sort of use and activity crosses over between the two. And why does it matter? Why does it matter which rights apply? Why can't we just say that all of the rights apply? Why should we care? Personally, I found it useful to think about copyright in general as having two functions or carrying two functions. And this has been a central thread that I've sort of applied, or lens that I've applied to a lot of my research. And it's not entirely new to think in terms of authorship on one hand, and I suppose dissemination access on the other. People have called it the incentive access paradigm, or this kind of balance that needs to be maintained. But rather than seeing it as balance, I see it as two functions that really has to be carried by copyright. And in my view, authorship has tended to attract a lot of, I suppose, attention, this notion of incentivizing authorship. And the argument, I suppose, is that you need authorship before you can disseminate content. So it's sort of what comes first. But I think it's really important that we actually look at how dissemination occurs, not just the fact that we want more content to be distributed to the public. And importantly, considering how these dissemination markets need to be efficient, how they need to be competitive in order for this function to be carried out to the best of its abilities. So when you have multiple rights, I suppose, applying to a single instance of exploitation, this could increase transaction costs. Multiple rights having to be licensed, it increases complexity. And you might question then whether this is necessary. You could say that, the royalties that will be available or will be received by rights holders, it's not going to get bigger if you split the pie into more pieces, right? It's just the same pie. So there's no sort of commensurate benefit for authorship. I suppose that's the way I'm thinking about it. And if you make exploitation or dissemination through these markets more difficult, ultimately that's not going to benefit authors. And so if we turn to legislative implementation, and this is where I get to the comparison between, I suppose, Australia and Canada. The terminology is slightly different, and you can see that Canada actually implements it. The terminology is much closer to the way it's set out in the copyright treaties, actually, or the internet treaties. But in both instances, making available is part of the communication part. So it's inclusive in nature. So communication includes making available to the public. And of course, what I'll talk about next is really how the approaches have really differed despite this similarity in its implementation. And there's also structural statutory differences, but to me, the big difference really is the attitude of the courts. So the Australian courts take more, I suppose, conservative approach, and the Canadian court, I suppose, in principle or policy, is more attuned to, I suppose, broader concerns, things like technology, neutrality, or user rights. But if I were to simplify, and if I were to really simplify, we'll try to show you how it looks like in terms of a diagram contrasting the Australian and Canadian approach to this making available, right? Particularly in the context of downloads, you can see that you could initially have a work that's either available for download or available as a stream. And in the first instance, when it's downloaded, it's fairly simple. I suppose you have a discrete act. You can say the reproduction right has been exercised, a copy has been made when it's downloaded. If it's streamed, that's a transmission. Something has been received very clearly. You have an exercise of the communication right by transmission. It gets a little bit more challenging if you're thinking in terms of potential downloads or potential access through a stream. When it's potentially downloadable, there's an argument that this constitutes a communication to the public, because particularly if you're looking at the WACO Internet Treaties and how they set it out, it really doesn't distinguish between whether you're receiving a copy or whether you're receiving, accessing it as a stream. So that's one argument. But in terms of something that's potentially streamable, that's very clearly communication to the public by making available. So that's actually the Australian approach. The Australian approach has been that you make something available for download and it's eventually downloaded. That's an exercise of the reproduction right. That's also an exercise of the communication right initially. So you could argue it's a single form of exploitation. But then if you look at Australian context, there's no particular decisions on this specific issue, but the collecting societies are collecting it in that way. So they kind of split the royalties for these two different rights between the relevant organization. And that hasn't been contested. But in this tariff setting decision that got appealed to the Supreme Court of Canada said, wait a minute, that's a duplication. That's an overlap of rights in the single exploitation. We're not going to go that way. We're not going to agree with that. And so they said that sure, a download may be an exercise of the reproduction right, but making something available for download is not going to be a communication to the public, despite arguments of SOCAN that it is. They said that it would be an authorization of reproduction. So the second, I suppose the second or the lower kind of road there is less contentious, right? Because of the way communication right is drafted inclusive of a making available of content. And so you might also ask yourself, why did the Supreme Court say it had to be an authorization of reproduction? Why can't we just say, oh, we're just going to protect reproduction downloads alone and ignore, I guess, when the act of making something available for download? Well, you have the added layer of the internet treaties, of course. So meeting our obligations and making sure that something being made accessible, whether as a download or whether as a stream, is still protected under a copyright right, whatever that right may be. So authorization, before I move on to these points, authorization, Australia and Canada both have described it as, sanctioned, approved to countenance the infringing activities of third parties, right? So you're not yourself carrying out these infringing acts, you're not yourself making things, but your authorization is kind of prospective or third-party infringement of copyright. The first point there, as I said, not contentious, on-demand access being part of the performance, so you can't really collect fees for making something available, and then when it eventually gets transmitted, you can't collect 2 fees. That's fairly straightforward and not contentious whether in Australia or Canada. The second point, the use of authorization does raise some questions, and I'll come back to that later on as we look at, I suppose, the different policy or principle approach of the courts. But I suppose broadly, as I said, the Canadian courts are more attuned to these issues around technology neutrality or taking a technology neutral interpretation of exclusive rights and also recognizing user rights. And a lot has already been said about those principles by Canadian academics, so I won't really go into it. But what I will say is that the net effect of these principles is that the court is much more sympathetic to potential complexity or inefficiencies that would affect, dissemination of dissemination markets. In terms of the doctrinal outcome or, the actual legal result that you have from these cases, well, the court said, making available, sure, it's a separate physical activity, but that doesn't mean it's a new and separate remunerable right. And how they arrived at this conclusion is really looking at the structure or the way rights are set out in the Canadian legislation. So you have the 3 sort of main rights being set out initially, and then you have, other rights that follow or are separately listed. And the court really said that copyright owners have these 3 interests, these distinct 3 interests, and the activity or the exploitative activity can only fall within, one of these interests. Contrast that with Australia. Australia just lists, rights of communication, performance separately. So there's that sort of structural difference in the legislation. So that's one of the reasons. The court also focused on this notion of control. They said you have to consider what the activity does in relation to the web. And they said that when it comes to exercise of the reproduction right, when you sell a copy to a consumer, for example, they receive the copy, they have control of what they can do with that copy of the work. Whereas when you're looking at performance type exploitation, so if you think about streaming, things that are coming from a platform, they said, well, you are able, or the person communicating or performing, you can limit how it can be accessed, the number of times that content can be accessed. So you could say the control is really retained by the entity that's disseminating content. So that seemed to be an important point to the Supreme Court. So if we come back to, I suppose, briefly, technology neutrality, what they're saying about this selling of copies is that, when you purchase a record in store, there's only exercise of one right, a reproduction. There's no, communication to the public. So it should be the same here, right? If you purchase a download online, it should also only implicate one right of the copyright owner. So that's the reasoning there. So I wanted to drill down a little bit more if we focus more on downloads, which I said could be a little bit contentious, and also why, as an Australian academic, it was initially, I suppose, potentially contentious, but if you look at the national implementation, as I said, initially under the umbrella solution, they said, we're not going to care about these overlaps. We're not going to care if it falls in your reproduction or communication. But ultimately, when you come to national implementation, the issue still arises. And the Canadian court has really focused on this historical distinctions between rights and interests, right? And they said that, a making available is really a part as defined as part of a communication, and a communication really is a kind of performance. So we're keeping this as a distinct interest. And so as they talked about the issues around control that I already explained. And so that's how you arrive at this kind of outcome. Whereas the Australian courts, as I said, performance and communication, separate rights, overlaps are assumed to be fine. They haven't really shown much concern for it. And as I said, collective administration is split between the different organizations. And it's not really disputed. So I just wanted to explain a bit more the Australian approach. And I guess really this is the point where I said, what are the lessons that we can take from this case as an Australian lawyer? And I'll try to be a bit brief about this. Well, the comparison is not really, I suppose, fair, because these Australian cases are the highest one was the Australian full federal court. So we're just still one level down from the high court, the highest court in Australia, and obviously SOCAN is a Supreme Court decision. But the decision in Optus was appealed. Well, there was an attempt to appeal it to the High Court, and that was rejected. So you could say that they implicitly, I suppose, accepted the result of the full federal court. But the key point from this case is really showing how Australian courts sort of take this overlapping of rights as a given and don't really inquire further. So the example here in the Optus TV case is involves the digital video recorders. You can think of digital video recorders as conventionally, perhaps you had a device at home. You could set the time, you could set a schedule, and ask it to record whatever program you wanted on free-to-air TV, right? The Optus case involved this, I guess, turning this technology into something that would occur through the cloud. So you had your app. Optus would set up antennas in different cities. It would record the programs if you requested it to do so. So you have background copies being recorded and then eventually being streamed back to the consumer when they chose to watch that program. So you have similar cases in the US, right? The Aerial case. And of course, the parties that objected to this were, the National Rugby League, the Australian Football League, very popular sports. And they wanted to protect their licensing deals. Their licensing deals were really about streaming of that content live. And with Optus technology, you could stream almost live, right? There's a slight delay. But what the court decided in terms of these cases, they focused on reproduction right. They said, well, these reproductions are occurring in the background. Sure, we have an exception for time shifting for personal use. That doesn't really apply. And if we're able to find liability for infringement of the reproduction right for copies that are being made in the background, that resolves the case. So we're not going to concern ourselves with whether this is an exercise of the making available right or the communication right, which I thought would be a much more interesting analysis, because really the value that they were trying to protect was not the background reproductions, was really the access by consumers, right? So that's what we have in Australia in that context. And this other case is two federal court cases involving Redbubble. So Redbubble is really, and I suppose you could describe it as an art merchandising platform. So third parties can submit their artwork and members of the public can say purchase it for, to print on mugs, t-shirts, stuff like that. And the point really from this one that I wanted to draw out was how Australian courts also don't really pay attention to overlaps between authorization of infringement and the actual infringement of the right itself. And here in the context of the right to communicate to the public. And the court said, well, your business model is built all around access through Redbubble. So when people uploaded, say, Pokemon and, the Hells Angels kind of logo, they said, well, that's infringement of the communication rights by the platform, because your business model is dependent on members of the public being able to view and access these images. So ultimately, they didn't show regard for the difference between you actually doing the communication. They didn't upload the content themselves. So Redbubble, the platform, did not upload its content, yet it was held liable for infringing the communication right. Now, the lesson from this, I guess, saying it's being drawn from SOCAN and ESA is really not that obvious. You have to extrapolate it a bit more and consider how the court in SOCAN was really conscious of the use of authorization and how it could be used to protect, I suppose, the exclusive rights. But the critique of this overlap actually kind of goes both ways, and this is, I suppose, sort of an interesting point. You could reflect on it both ways in the reverse. So in Australia, we're using, I guess, an exclusive right to protect authorization. What really should be authorization? In SOCAN, you're using authorization to protect something that really should be protected as a primary sort of exclusive rights. So I guess less obvious point, but essentially, there's a lot of overlap, and I think the Australian courts still could learn from Canada in the sense of being more mindful of these overlaps and also addressing it, I suppose, in the decisions. There's just no real, clarity in addressing these points. So this one I can deal with fairly briefly. So in the international perspective, in terms of countries looking at the Canadian approach and saying, well, what does this say about our obligations? How does the Canadian approach fit with the obligations under the WIPO Internet treaties? So as I said, as an Australian law academic, I looked at it and said, well, how can you actually use authorization to protect making available to the public as a download? The reason why I thought it was a concern was because in Australia, authorization of infringement requires proof of the actual infringement having occurred. So, for example, if I make something available for download and the copyright owner wants to sue me, I actually have to prove that someone did download that content, that it actually happened. In Canada, it isn't. So it's being described in that case as a distinct right of the copyright owner. You don't actually have to prove, it's not dependent on that download actually occurring. So that's an important difference in the two countries. So once you understand this point, then you realize, well, hey, actually, the Canadian approach is probably fine on the WIPO Internet treaties because mere access satisfies the infringement requirements. The second point, in terms of the standard of liability, is a little bit more tricky. So the question that arises then, again, taking a Australian approach, is if you look at authorization of liability, this notion of sanction, approving, or countenancing the infringing conduct of a third party, you would argue that's a fault-based standard of liability, right? Potentially some mental factors. And then you would question, so under the Internet treaties, is it permissible? Must liability be on a strict level of liability, or is a fault standard sufficient? So there's two arguments to that I set out in my paper in this regard. So the argument is that, well, the umbrella solution is fairly broad. It doesn't really state, or the Internet treaties don't really state, what standard of liability has to be applied nationally. But importantly, if you look at it in a substantive way, if you look at the way the courts applied this authorization, they didn't really look at any of the mental states of sort of the infringers. In substance, the mere fact that content was made available for access, that in itself, met the requirements for authorization. So in substance, you would say it doesn't really require fault in any case. So I argue in this paper that that it's actually meets the requirements of the WIPO Internet treaties. So what about, I suppose, broader questions? Is the Canadian approach on authorizations, is that perfect? I would say that it raises some questions. And Evan Dressnauer wrote a very interesting comment, and I agree with this. The point really is that, when you look at communication to the public and you look at how making available fits within communication to the public, there is this juridical homogeneity, that's what he calls it. They are the same rights, it's encompassed within the communication. On the other hand, if you say that authorization of reproduction and reproduction are distinct rights, doesn't that then create its own duplication, where you have separate rights applying, again, to the same activity? I would say that it is still better. It still, in a way, limits overlap because you have same rights supposed being applied in this instance, even though you say authorization and the eventual reproduction is separate. It's still at least held by the same party. So, if you're thinking about licensing complexity, it's still, the same party that you're seeking a license from. Despite this sort of critique, I think that the Canadian approach sets an interesting example for the world. It kind of shows how you can split these sort of two activities and two realms of, downloads being reproductions and streams being communications or performances to the public. There could be, I suppose, remaining tensions. It sort of shows how courts are struggling with how making available rights sort of fits within existing frameworks and existing exclusive rights. There's a question of whether authorization is really a good long-term solution. In my view, it sort of seems like a patchwork solution where courts say, oh, well, we have to protect making available to the public for downloads. Let's just say it's an authorization. And if you think about why authorization is in place, or why the common law sort of developed this notion of authorization, it's really for finding a central, I suppose, entity lives for the activities of third parties, right? It's not really saying this is something that you can use to protect a primary right. Is there a better alternative? So it's I'm not saying that these are better alternatives, particularly for Canada. I'm just saying generally it was for Australia, for other countries. If we say this is a patchwork solution, is there other better longer term kind of aims for copyright? And I have to admit that these proposals that I put up, they are or will be a challenge, definitely in the immediate term in light of existing practice. But these are proposals for the, I suppose, the reproduction right and the communication right in the context of downloads, and in light of the communication right and how prominent it really is in this online environment. So one possible proposal really is to simplify things and say, if you make something accessible online, this is a communication to the public alone. So we don't really distinguish between whether it's a download, a stream, a reproduction. We say if something is made accessible online, this is a communication to the public. But while it sounds like a really expansive approach to the communication right, you would tend to, in order to avoid overlaps, you would then have to have these other, activities or other rights that apply contract. So you might say the reproductions that result from that shouldn't be an infringement because it's already covered by the right to communicate to the public. Again, you don't want multiple rights being applied to some single instance of exploitation. And this argument around contracting as opposed to reproduction right can be challenging in light of existing practice and also in light of treaty requirements. A second potential possibility is to go along with, I suppose, the SOCAN approach. But in light of what I said about concerns around authorization, you could argue that, a reproduction right might be repurposed, reframed as an access-based right, I guess as a counterpoint to communication to the public by making available, saying, if you make reproductions available to the public, that's an exercise of this access-based reproduction right. So it sort of kind of develops this two-track kind of, I guess, framework for copyright. But also question whether it's sustainable, given that, the distinction between downloads, streams, reproductions is increasingly being blurred. Third option is to do nothing or do what Australia is doing and assume that overlaps are the norm, but I wouldn't really particularly be pushing for that proposal. So that's all I have to say for today. I really, really welcome your questions and comments and feedback. Thank you very much.
Thank you so much, Hannah. So we have some time for questions and answers. We can take those from the room, but also I know people are joining us online as well. So I think the Q&A function should be working in the Zoom room, or you can use the chat function if you do want to send in any questions. And Emma, I meant to introduce Emma earlier. She is the Assistant Director for IP Osgood, and she's managing the Zoom room, so she'll let you know if there are any questions there. But let me begin by asking if anyone in the room wants to kick things off with a question. Any brave souls who have something they want to ask? I have lots because this is like exactly what I spend my time thinking about. But I'm not proud of that. It's too much time. We're like too in the weeds on all the doctrinal niceties. So even if you have big picture questions, we're happy. I'm sure Cheryl will be happy to take them.
Right.
Yes.
I only have basic questions because I've never taken copyright, but I'm just curious with that example of Spotify that you gave. So would you be subject to Spotify's pricing that's offered for making available versus sorry, I can't remember the other option, but there were the two options. Or is it like now Canadian artists are able to negotiate that for like each work with something like Spotify?
So I don't know the exact way it would be negotiated or how it's being dealt with by Spotify, right? I suppose there's a difference between a tariff setting decision that might apply to the collecting societies and how Spotify might deal itself, with the parties. That's essentially, you would say that falls into private ordering, right? How you decide to deal with it. But the convention that has sort of come up in the context of collecting societies is having this sort of bundle approach. So we're going to license for this activity. We'll say it covers these different rights, and we'll kind of apportion it later on. So that's the sort of solution that you could take. It works well, I suppose, for collecting societies. You have centralized organizations. It works well for Spotify. But then if you think more in terms of something like a startup, someone who doesn't have access to these sort of established frameworks, it's a lot harder to then say, oh, I need to get these rights from these multiple copyright owners in order to be able to exploit it in a single instance. Or perhaps a organization that wants to start sort of a licensing administration system. Maybe it just becomes a lot more complicated in those contexts. So if it's already established, if you're a big player, sure, that's easy. But I think this added complexity just means that it's a lot harder for normal people in general. Yeah. I don't know if that really answers sort of.
How does the making available rights get engaged for open source AI projects that do a lot of big data sampling? So in a way, every single answer that ChatGPT gives is a sampling of every data that it actually was input into the system. So how do you think copyright law should actually tackle this issue?
And that's a great question, and it sort of takes us beyond this topic. But I'm very happy to give you my thoughts, and I'm sure Karis probably has a lot to say, or a lot of people will have a lot to say about this topic in general. I have written a paper considering, I guess, a more narrow question, the background copies, and there are certain arguments around how copyright works might be used in different ways. So if you as a person, for example, are reading something, you could argue that's sort of an expressive use of that work. You're reading it, you're perceiving it as a form of expression. When you're thinking about things such as data mining, for example, you're kind of extracting data and information. There's an argument that it's sort of slightly different from expressive use. You're using information contained within. It's more sort of a functional kind of use of copyright content. And I think that categorization obviously can be contested, right? It's obviously a blurring of the boundaries between the two. But it really comes down to, I suppose, a really fundamental principle of copyright that protects expression, but it doesn't protect information or ideas, the idea-expression dichotomy. So you can talk about these broad principles, but when you actually come to apply it, it's probably a lot more challenging, I would say. And I think it is quite contentious how you could have companies sort of come up and swoop up a lot of content and use it to train AI. So that's the issue where I suppose at a policy level, you need to determine whether that should constitute an infringement of the reproduction right. You have reproductions occurring in the background. So on the one hand, there's an argument, it's not really expressive use, you're not actually reading it, but the computer is reading it, they're using it in some ways. Should it be the reproduction right? Or should it be a different right? Because reproduction right, if you think about conventional sense, about printing copies for someone to read. Yeah, so there's slightly different considerations, and I think there needs to be a nuanced discussion about the differences rather than just assuming it is a reproduction. What I have thought further about though as well is sort of making available to the public, right? The background copies aren't making available to the public. So if you're talking about ChatGPT or OpenAI, you would then come back to core principles, idea expression dichotomy again, and then say, are they actually reproducing or communicating to the public expression? So perhaps they read, they learn, and they may regurgitate it in some form, but it's not actually the same expression, right? It's ChatGPT's expression in some form. So you could argue that that's not a communication to the public of existing copyright works because it's, it's in a different form. So that's more kind of like an application argument around communication to the public. Does that answer your question, or there kind of?
I think there's a lot more dimensions than just saying that it's only a novel expression, just because there are also applications for AI to actually copy image styles, right?
Yeah,
So in a way, that's also a reproduction, arguably.
yeah, yeah.
So there's just because there's so many different ways to use the technology
Yeah.
that pretty much every single write can be like engaged in some way, and it's really hard to like to put it in a single box.
For sure. Totally agree. It's very easy to just discuss it in terms of broad principles, but when you come to the actual application and look at, oh, this style is really close to something, and then you might ask, well, it come back to existing cases and say, does copyright protect styles, or what's the distinction between ideas and expression, right? So it comes back to those sort of principles.
I just think one of the things I really liked about the second proposal, I've got that right, which is like maybe reproduction should be reframed as an access right. That you stop thinking, even though it's copyright, you stop thinking that the right is just about the fact that there's a copy, because there are digital copies everywhere, always, whenever we do anything with digital technologies, and actually start thinking about the nature of the copy as something that is accessed. And we could say read or enjoyed, and I would say the machine's not really reading, because it's not interpreting the information, but we can quibble over those things. But I think that idea that maybe this notion that every sort of technical copy behind the AI implicates the reproduction right and copyright should care about it is becoming increasingly problematic in the digital age and the AI age, and maybe that's one route towards that answer, if that's the answer that we want, right? But it doesn't mean that the outputs couldn't be substantially reproducing inputs in a way that ultimately would be infringing if they did, reproduce the expression. Right? Does that sound fair? Yeah. So I like that, but I think you might get into trouble because a lot of people don't like that.
Yeah.
Sorry, there's another hand.
Hi, I'm a OneNote, but also a SOCAN member, so this is going to be extremely layman question. I can think of many cases where there's multiple like rights or royalties due. You buy a record, you play it at a jukebox, you learn the song, you play it in the bar, you play it on the radio. There's multiple royalties along that process, depending on what happens. But would there be any ways that this ruling could impact the old ways of doing stuff, like the new technology, the streaming, looks backwards on the other ways of doing stuff? And I guess that's the point too, that there's just a simple, it's out there thing, and then just how you use it is when the royalty generated.
So sorry, I'll just see if I understand the question correctly, and please clarify if it's incorrect. So are you thinking in terms of, if we say take these proposals, does that mean reproductions in the conventional sense might not be adequately protected, or sort of like jukebox or the other thing?
Well, I suppose if it's quantified, the moment that it's streamed is like there's no additional making available. It's one royalty, whereas now downloading it's the same thing. Downloading is not a separate entity, but if you buy a record, a royalty is paid, or if you use like a mechanical royalty is paid, and then if you play that at a bar, the performance royalty is paid out. Does the fact that this new technology has changed the way we look at the way that like royalties are assessed, would this have any impact on the old ways of doing things?
Yeah, I think I'm going to say when the initial move was made by the Supreme Court to say there's no layering of rights and double dipping and royalties, I think there was a collective kind of, oh, is there not? I think that's what we've always been doing. And so it was a kind of line in the sand that made us, I think, reevaluate some of the past practices that made it harder for people to collect royalties and things that they had previously thought they were entitled to. So, for example, there was a ringtones case where ringtones were being downloaded onto people's phones, and it had been assumed that this was a performance because it was a transmission of the digital file that was the ringtone. And so then there was litigation over whether all of those royalties that had been collected for the ringtones for the communication right had to be given back, because in fact, they weren't owed. And we sort of sorted this out saying, well, going forward, the tariff won't be renewed because now it's clear that that's not a communication right issue, it's a reproduction issue. But it is interesting how the new technology has required this much more careful sort of parsing of rights that we weren't really engaged in before. And then I think you're right, it has required sort of a reevaluation of some of the past practices in the industry, and that will continue going forward. I don't know if that's
Awesome, thanks for the question.
Thank you for your patience.
No, it's an excellent question.
I mean, it's a great way of thinking about it. I suppose I'm always sort of thinking forward, and that's a great reflection on how it might change our ways of doing things. And I have thought about this issue in the sense of some people might argue, well, yeah, layering of rights that happens, right, in the context of subject matter, on the question of subject matter. You have someone who writes a song, underlying kind of music being protected by copyright. You have the recording company having rights in sound recording, or even movies. You know, there's so many layers of different rights in a single output. But the difference that I see there and in this sort of discussion is that with those sort of subject matter questions and layering of rights, it's actually tied to the input, right? You want to recognize the creative or investment input in that subject matter. So yes, it's perfectly, in terms of if you're looking back at the two functions, incentivizing authorship, you have to recognize those rights and interests. But here we're not really talking about that sort of commensurate kind of recognition, right? We're talking about single kind of conduct or act of exploitation and how that could impact multiple rights that are potentially held by different owners. But that's more to do with the fragmentation, I suppose, of rights, how they can be further transferred to different parties and therefore lead to different owners, and therefore that complexity in licensing. So I guess that's another point on that.
Any other questions in the room or online? Can I have a stab at mine?
Yeah.
People
Oh,
feel free to
there's
cut
one at
that.
the back as well.
Oh, well, okay, that's a good idea. No, go on.
This is just something that I'm not really sure whether I would be putting in the opportunity in the right context. But I'm just wondering about how this might work with third parties, the infringement of just access rights with third parties. And I've got a hypothetical example of it. So let's say that you've got a conference of a similar nature that's happening at a for-profit convention center. And then we've got a question that's asked about, oh, you know what, I saw something on an XYZ website, and then they direct the person who's presenting it to that particular website. And the presenter opens the website in the conference room before everybody, and then there's copyrightable music that is played in the background. So while you're reading the text on the website, there's music in the background that's playing. Now, what is unknown to the organizers of the conference is that particular music is copyrighted by one. Second, the person who's put it on the website did not have the license. So it's unauthorized in which means now we opened it here, it's playing in the background, we heard the music, so it's being accessed by us in some ways. The question then is, if tomorrow the owner of that particular music wants to sue or make liable the organizers of the conference, how would that be approached?
Thanks for your question. And that kind of raises a point that I talk about in my work in progress paper, but I didn't really have time to address here, which is that copyright or the exclusive rights, whether it's the exclusive right itself, whether it's authorization, it should, in principle, really apply to traders, right? Not really to the conduct of consumers or the everyday conduct of consumers, whether you're reading a copy of a book, whether you're streaming it online, receiving it, it shouldn't be what copyright is designed to do. And that's my additional, I suppose, criticism of that authorization approach of the Supreme Court. So if you look at communication to the public, which we say have this juridical homogeneity, or is clearer, I suppose, is that it very clearly only applies really to the conduct of someone who's communicating the content or making it available to someone else. If you receive it, well, particularly in Australia, there's a specific exception that says if you kind of open a website, for example, that's I forgot the terminology in that statute, but really it's saying if you initiate to receive something, you're not the person communicating the content. You're not liable for infringing. It's really the party that puts it there, right? But if we say that in the context of downloads, that the download is a reproduction, say, by third parties, by the consumer who initiates the download, and then you say that the platform or whatever disseminator is authorizing those infringements by third parties, aren't you then saying using, I suppose, relying on infringement of consumers in receiving downloads in order to satisfy this protection of making available to the public of downloads. So that's sort of a potential criticism of that. But yeah, in the context of access, or that example there that you said where you're just really listening, you're highly unlikely that you would be found to have infringed any rights. Really, it's the party who played the music or organized the conference, and you could say you could rely on authorization, or you could argue with some kind of public performance or communication.
I agree, with the only caveat maybe being that if the party continued to let the music play, then maybe they've implicated themselves in actually being responsible for the performance, as opposed to just receiving the performance from the third party. But it would be unfair, but that's part of the absurdity of copyright law. When you start running paper hypotheticals, it usually leads to a fairly absurd result, because of course you don't actually need to have any intent to infringe, or any knowledge that you're infringing to infringe, and so all kinds of people can get into trouble. But I think that was our, our 2012 initiative in Canada. Lots of those sort of changes that were made to the Act were designed, I think, to sort of centralize liability in a way, or at least to move it away from the end user, and who's just engaging in everyday activities with new technology, and actually find who's the more sort of culpable or responsible party. And that's why making available and authorization have that sort of centralizing effect that is attractive to policymakers, but has the potential to create those layers of rights and layers of infringements and liability that we also find problematic. So it's a challenge. Okay, I have one last wee thing, and I had like 3 questions I'm going to try and bundle into one thought, and you can do with it what you will, and then, or you can just tell me to stop. But I think so. I think it starts with this, and this is just maybe because we're in, especially for people who are just sort of encountering copyright law, the technicalities of adoption for the first time. I think it's important for us to acknowledge that the actual technicalities of how we draw the lines in these sort of doctrinal questions, is it this right, is it that right, what's the scope of this, and who there's always a risk, right, that we're over lawyering it and we're kind of missing the point, right? And the actual point is that when you have new technologies, you open up new routes towards exploitation, new routes towards private profit, and that current stakeholders or new entrants into the market are going to try to find those new technologies and use them to create new or additional revenue streams, right? So that's just the reality of, I don't know, let's call it capitalism. And so what flows from that, though, is I think that there's going to be a natural pressure towards the proliferation of rights. Like that every new activity that we can do with new technologies, there's a notion that we have to be able to capture it with a right, so somebody can monetize it and profit from it, and so somebody must be able to control it. And then there's just this notion that if there's a new activity, there's a new right. And what I feel from the Supreme Court jurisprudence over the last little while, in contrast to what we've seen in Europe, is that there's been a real effort to try to restrain that natural proliferation of rights. And I think that the technological neutrality principle is doing a lot of work there, right? Like we're trying to maintain a balance between protecting owners, encouraging authorship, and encouraging dissemination. And so the way I understand technological neutrality is that we're going to be rebalancing it, we're going to be thinking about that balance in the context of the new technologies and trying to strike essentially the same balance so that we're not upsetting it and suddenly there are more owners with more rights and users have less space to move and so on. And so I suppose the big question might be one, like, what's the role of technological neutrality as you see it? Is it helpful? Has it been? Is it kind of an empty concept? And to what use can be put it? Does Australia need a better developed principle of technological neutrality? That might be the other one, right? So what is the comparative implications of what's happening in Canada for Australia? We have the same historical roots, we have notionally the same purposes behind our Copyright Act, but you're seeing a divergence. How do you expect Australia to be looking to Canada? Do you think it should be? Yeah.
Well, a short answer to that last question is yes, I think it should be. And I think I really admire how the debate that occurs between majority and dissent and that sort of reliance on the principle of technology neutrality and how the dissent really used technology neutrality in such a different way.
Yeah.
They're sort of talking about the same principle, but then applying it so differently to the same context, right? And that's not necessarily to criticize the principle, but to say that it actually generates that kind of discussion that is lacking in Australia. So the Optus TV case that I mentioned from Australia, technology neutrality was actually explicitly discussed in the case, right? But then the court said, oh, well, our provision is clear. There's no room. I suppose they take a fairly conservative approach. Actually, if you read the language, I would say that there was room to take for technology neutrality to play a bigger role in the interpretation. But to them, they'd already sort of, I suppose, decided, oh, that's the finding, and that's what it means. And so they weren't really challenging themselves, I suppose, in that sense. If I applied that criticism to that case. What was your other question? How can Australia use technology neutrality? I think because of the way we've been so conservative, unless that changes, I don't think technology neutrality is really going to push us in any real different direction. And the issue isn't really about whether technology neutrality exists in Australia, it's more the way they approach it. And also that I suppose approach to user rights, right? I don't see that ever being a thing in Australia. And so you talk about, I suppose, new routes or new ways of commercializing or exploiting content, and how that kind of leads to potentially different or new rights. I think that's why I kind of prefer option one, because it kind of simplifies things a lot more to say that's a communication to the public. And that's why I do have a bit of a criticism in terms of the courts saying, oh, this is like buying a record from a record store. I think that only kind of gets you so far. Those kind of analogies, looking at the old technology, sure, the balance was maybe retained in that context in terms of the technologies. But will that analogy continue to hold going forward if you're thinking in terms of that sort of, balance of interests and rights? And I would say it might be helpful to a point, but I'm not sure. So yeah, did I answer? Because there's a lot of parts to it. I wasn't really sure if I got everything.
That was perfect. You covered everything, and
All
that
right.
was very helpful. So I will let you stop there. Unless anyone has any last question. I don't think there's any online either. Okay, so then with that, let me just say a big thank you to Cheryl for joining us today for our first live panel. Well, thank you all for joining us as well. Continue to eat, and thank you for joining us online. Sorry we can't offer you food. Maybe we'll see you here next time. And as I say, stay tuned for September 22nd, and then October, we think October 12th. And I'll be in touch with you. But let me know if anything I've said is of interest, or you can email Emma as well. We're at iposgood@osgood.york.ca. Okay, thank you very much. Thank you.
I think I would.